Thanks. Before we begin, this is not legal advice. Uh, we're not lawyers, we're just journalists who report with limited knowledge about these issues. What we'll cover in this discussion is essentially regulation of online calling and messaging. We'll look at the current consultation, but we've also culled out different parts of previous consultations that the TRAI, the DOT, MeitY, and in some cases stuff from MeitY, to give you context on how we've got to where we are. And we'll also talk about the blocking and banning of apps and internet shutdowns. We have the privilege of having Apar Gupta here with us. Apar and I have been looking at these issues for a very long time. I think starting from the first IT rules in 2011. And so Apar is also here for any points that he wishes to make. And I think after we're done with the presentation, we can have a Q&A. Apar, if you're okay with that being on record, great. So we'll take it as it comes. I'm sorry, I'm a little underprepared because there's been some flooding in my area in Delhi, and we've had to evacuate a few people yesterday, but everyone's safe. So we'll give you an overview of the environment that we're doing this discussion in. So a few years ago, we were at the TRAI consultation on regulation of OTT apps, which are focusing primarily on online communication apps. And at that discussion, there were maybe about 4 or 5 retired armed forces personnel, and they hogged a large part of the conversation, talking. And there was Lieutenant General Chaudhary, who was, I looked him up, he was retired. So he used to be the Lieutenant General for Military Intelligence. And he was there at this discussion, basically saying that, when there's an ID blast and all communications are shifted to messaging services, how are we able to track what sort of communications are taking place in Jammu and Kashmir? So encryption is a big problem for them, essentially saying that where is your free speech if there is no security? There's if you want to avoid regulation, it doesn't mean that you forget the nation. So there was a lot of national security rhetoric at that discussion. Also he mentioned that militancy is increased in the Kashmir Valley after OTT services had launched, and a large part of the tracking that happens, and he said this someone said this on record, there happens on online services. So there was a very, very strong call for regulating online services. Some of us raised the issue of proportionality at that discussion, but it was quite overwhelming. And that's the environment sort of that we're looking at, that this is largely coming from a security perspective. They also pushed for data localization. But again, all conversation was shifting towards, the impact of militant attacks on citizens, and the fact that communications happen from outside the country, and all servers should be located within India. So that was broadly the place where we left that consultation, even though the TRA's final recommendation was much sharper and actually said that there is no need for regulation. But that's an environment that we should expect, frankly, when this consultation goes into an open house. So we looked at this consultation paper, and the while the TRAI recommended that there was no intervention needed, the DOT is now written to the TRAI last year in September, saying that they have not provided any detailed justification for recommending no intervention. This is, of course, despite the fact that many of our submissions pointed out why there is no need for this, and that online communications is an integral part of all types of communications. The other thing that the DOT said in its letter is that these recommendations are at variance to the previous recommendations on privacy and security and ownership of data, where they've said that there's a need for regulation to ensure the privacy of consumers. And also it cites a parliamentary standing committee on communications and IT saying that they need to look at selective banning of online services, specifically name checking like Facebook, WhatsApp, and Telegram. So that's the context in which the DOT has asked. The consultation highlights what OTT is. It wants the issues for consultation are the issues that we've seen before, which is the definition of OTT services, their classification, they're looking at the features of OTT services in terms of how to distinguish it from other services for communication, and again, classification of those. Apart from, whether there is a need to bring communication services specifically under a licensing framework to promote competition. And I'll get into what telecom operators have been saying over the past decade or so now regarding the competition with online communication services. Of course, lawful interception makes its presence felt here, as it will in during the rest of the processes as well. They're asking about how this impacts net neutrality. And then they go into the selective banning of online services and websites in specific reasons, in specific regions, and how that banning would actually happen in terms of classes of services, what would be the mechanism for it, whether there's a need for banning specific websites and not just services. Of course, what we've seen is that there's a look at whitelisting as well. But all of this began for us with the TRAI consultation in 2015, where they looked at zero rating, at licensing, and separated from licensing and zero rating, they looked at net neutrality, which is speeding up and slowing down, or at least that's what the definition was then. This consultation process, Apar, I, Raman Chima, Kiran, Jonal Gadda from Hasgeek, and a bunch of us, we launched the Save the Internet campaign at that time. And that consultation process basically remained inconclusive. The TRAI then sliced up that consultation process into three separate consultations, one on speeding up and slowing down. They only adjudicated eventually on zero rating before doing a net neutrality sort of recommendation. And the licensing framework stuff is what they closed in 2020 by saying that there is no further recommendation on that issue. Around the same time, there was a DOT process which suggested that zero rating should be allowed on a case-by-case basis. Managed services should be exempt from net neutrality, and that there is no need for a licensing framework for messaging apps or regular app, but said that there should be licensing for domestic internet telephony. And I'm saying this because it's relevant to the regulation of online communication services. This report is relevant from that perspective. In 2008 is when that last of those consultations took place, where they were looking at licensing fees, spectrum usage, lawful interception, introduction of emergency services for online apps. Some of this has also found itself in the in the convergence consultation as well. But what Reliance Jio said at that time, and it's an echo of what they said in 2015 as well, is that there is a functional substitution, and there needs to be areas like national security and data protection. Those aspects should be applied to communication services. They've said that there needs to be a light touch mechanism. In 2015, they had recommended in their submissions that there should be a registration mechanism for online communication services, and that telecom operators should essentially regulate online communication services. They also said that the IT Act is insufficient in this regulation, and that from a national security perspective, there needs to be a regulatory framework for online communication services. They also highlighted data localization, and these are from my notes from the consultation that happened. And in fact, we have a live blog of that entire open house discussion up on MediaNama. I looked at it a couple of days ago, and there's still some typos there because I was typing really fast. So if you don't mind the typos, you can go and check some of that out. But I think I did a piece following that, which looked at the themes that came out during the discussion, and I think national security was mentioned some above 15 times in that entire consultation, or maybe more than 20 times in that entire consultation. So, like I said, that discussion was heavily impacted by national security considerations. In 2020, the TRAI made its recommendation, saying that it's not an opportune moment to recommend a regulatory framework of OTT services. And it said that these may be looked at afresh when more clarity emerges, particularly with respect to a study undertaken by the ITU. This consultation paper, and I'm sorry we forgot to include it in the presentation here, does reference some findings from the ITU. And also, if you remember what I said at the beginning, that one of the reasons why the TRAI is looking at this again is because DOT has said that even though it made a recommendation, they feel that they didn't justify the recommendation enough. So this is a process all over again to perhaps create a justification for regulating online communication services. And one of the things I've been talking about internally is that how many consultations will the TRAI do to regulate online messaging and calling? Will they keep doing consultations until someone everyone finally gives in and says that, yes, let's create a framework? Because pretty much a response broadly over the last few years has been, or ever since they've tried, has been that they shouldn't be regulated through this mechanism. But every few months, sometimes every few years, they do a fresh consultation asking the same questions, highlighting the exact same issues year after year. So, here we are again. So yeah, in the ITU recommendations, sorry, I think someone in the team must have included this. They've basically suggested that telcos should be allowed to offer their own applications, transition to data-centric mechanisms, and sort of develop frameworks to enable voluntary commercial arrangements between telcos and online platforms for investment in internet infrastructure without subjecting them to traditional telecom regulations. And then, refrain from extending legacy telecom regulations to online platforms, and look at reducing the regulatory burden on telecom networks, which is something which I think we've also highlighted in our submissions, as have many others. But the revenue share mechanism is actually come up in the EU as well. And I think there is a consultation process which is probably ended by now, where they're looking at the same sending party network pays mechanism, which basically creates a situation where large platforms which have which which are used a lot by consumers like you and me would have to pay telecom operators to make those services available so that telecom operators can invest in the network. That's the rationale. And of course, there's this idea of free riding, which is a phrase, which is again a telecom phrase that we've seen for a very long time. I'm just going to go jump past this to and come back to the previous because this is from looking at what telcos have said. This is what they said in 2014, saying that a revenue share mechanism between over-the-top service providers and telecom operators. That the telcos are investing in the network and online services are making money. There should be a fair revenue share. Rajat Mukherjee, he passed away a few months ago. He was working with the Broadband India Forum. But at that time, when he was working with Arya Cellular, he used the word riding for free, which we're also seeing in the telecom, in the ITU recommendation. In the same vein, Martin Peters, I think, also in another comment, maybe not this one, talked about free riding. And another one, that phrase that we hear quite a bit. Yeah, here it is. The other guys have a complete free ride. So talking about a level playing field is something that we see quite often. And this is all going back to 2012 to 2014, right? Saying that telcos don't have an incentive to invest in networks, and there'll be slower growth if they aren't allowed to make money from online services. I don't know, it's been what, 9 years since then, almost. Telecom and internet growth in India has only accelerated since then, right? So again, the other angle that we've seen from almost a decade ago is that there is no quality of service for online services. We're seeing much of the same arguments in the telecom bill, in the consultation related to the telecom bill, in the TRAI convergence consultation. I mean, the more things change, the more they remain the same. In fact, one point in time, and I think this is up on MediaNama, I created a telecom operator playbook about what arguments they use. And as you can see, these are the arguments that they use. Sorry, to go back. Right, so the other part that we look at on OTT regulation or the online app regulation is in the IT rules, where they've tried to enforce traceability, again, one of the national security angles in this consultation, where the IT rules say that when the originator is in India, they should be able to identify the first originator of a service, of a message, and otherwise, when they're not in India, the first Indian link should be considered the originator and they should be identifiable. Apart from that, they've tried to suggest that significant social media intermediaries should use automated tools to take down content. And there should be a 24/7 nodal officer to assist law enforcement agencies. That, of course, is currently in courts. WhatsApp has filed a case against these rules. Apart from that, you have, of course, in the convergence consultation, there was again a question. There was same arguments, right? That online services are operating in the same space as telecom services, different regulatory operations. So therefore, there's no same service, same rules. There's an impact on SMS and voice call businesses. big tech firms, say that they are not similar and should be regulated separately. It's the exact same stuff in the convergence consultation as we are seeing in this paper. And again, issues of quality of services, that it's difficult to differentiate between the responsibilities of online services and service providers, and the TRAI's job is to ensure that there is a high quality of service. How do you assign responsibilities? So like I said, we're seeing the same arguments. And again, like in the telecom bill, the TRAI in that paper has also said that there's a need to expand the definition of telecommunication services and bring online services under the same ambit. So there are we're seeing the exact same consultation over and over again. So in case anyone wants to respond to this consultation, please use the same, like you can use submissions made last time and just copy paste them by the looks of it. The other is about banning of online services, and essentially India has had the highest number of internet shutdowns in history. In many years, we had over 100 internet shutdowns in the country. In case of Jammu and Kashmir, there was a shift. There were different approaches taken, right? There were in instances the internet was shut down for 6 months to a year at a stretch. Akash Hassan, who wrote for us on this and also participated in a discussion that we had held around the same subject, he joined. He had mentioned that sometimes to file stories as a journalist, he had to go to a government official's office because for them BSNL was still active. And right now we've seen an extended internet shutdown in Manipur. Internet shutdowns have happened even when there have been for exams in multiple states. Darjeeling, for example, a few years ago had 100 consecutive days of an internet shutdown. So we're seeing suspensions of internet access, both short and long term. At one of our discussions, in fact, we had a situation where one of our attendees was an ISP from Rajasthan, and he brought on a police official from Rajasthan to explain what they do. And the police official basically said that they feel helpless when there's a riot that's happening and messages are spreading at a rapid pace. And for them, they see it as a last resort, but they have no option but to shut internet access down because they're unable to be in a position to stop the spread of these messages. Of course, they don't take into account the human impact of shutting the internet down, and there is no rationale for long-term suspension of internet access. But it's what we're seeing across the board, that the internet access is the first casualty of any conflict. And I'm a bit concerned that as we go closer to the elections, we'll see more political fermentation of violence, and as a consequence of that, more internet shutdowns going forward. While the Telegraph Act allows internet access to be shut down, very clearly, like in the Supreme Court of India has said that there must be a principle of proportionality, and it should not extend beyond the necessary duration. Now, those are broad phrases, and necessary duration is a subjective assessment. But the review committee must meet to reassess on a regular basis. There have been multiple attempts to create rules for bans, and maybe Apar, you want to talk a little bit about what the current rules are and how they operate?
I'll come in later.
Okay. So I'll leave that for you.
Yes, because it may disrupt the flow of your presentation, right? So
Rapa, thanks. We also have Section 69A is a much contested rule. Uh, we looked at it during the Shreya Singhal case, and frankly, one of my disappointments was that wasn't overturned simply because the Supreme Court felt that we can that there are adequate safeguards in processes. Unfortunately, no one knows or no one is able to ensure that the processes are followed in Section 69A, and that's why we're seeing uh, internet blocking happen in any case. One of those blocks was the ban on Chinese apps, where initially, I think it was June 29th, 2020, that some forgotten the number now, maybe 59 odd Chinese apps had been banned. Overall, I think 118 odd apps have been banned, if not more. But those were Section 69A orders. And then a couple of years ago, post the farmer protests, we also saw censorship of entire accounts, and including a member of parliament, his tweets were also censored. So proportionality in blocking there is something that we haven't seen, and unfortunately, that's actually been reiterated by the Karnataka High Court. Where they have uh, essentially held that the government of India has the power to block entire accounts as well. Not something that I agree with, because the impact of that is that you're not just banning contentious speech if it is illegal, that is, um, and but you're also banning or preventing future speech. Um, so the proportionality is that the Supreme Court had talked about is something that the Karnataka High Court has not looked into. The other disappointment that we had around that was that they didn't disclose all the tweets that Twitter had sought, that had the orders for blocking tweets that Twitter had sought to challenge in the court. There were, I think, 30 or 60, so that 16 or 39, I've forgotten, 39 maybe tweets. And I think it should have been made public for everyone to see what the government of India is trying to block, because these blocking orders are typically shrouded in secrecy. So, this is the environment in which this TRAI consultation on blocking in particular is taking place. In the Anuradha Bhasin case, the Supreme Court order, there was, uh, you know, there was a whitelisting provision that sort of came in around that time, that there will be that the government was asked to identify certain services that will be made available, um, and so that at least some access is available to people. Um, and I think what we're looking at now is a shift from a whitelisting approach to a blacklisting approach. Whitelisting has made another appearance, um, you know, more recently, where in Manipur, where while the internet has been shut down for an extended period of time, firstly, they're allowing for internet access to be opened for leased lines, which mostly businesses have, and as well as fiber to home, but not mobile. And then there's an expert committee that's recommended that whitelisted mobile numbers may be allowed to access the internet. And so that's a different kind of whitelisting. But of course, that uh, there should be blocking of social media websites and VPNs, as well as prohibition of new software installation. Allow physical monitoring, something that we've seen extensively in Telangana in particular, that people, and also in JNK, where the law enforcement agencies have taken people's mobile phones to see what they have on their phones. We saw this particularly when there was an attempt at a ban on VPNs in Jammu and Kashmir. So of course, and there's a ban on Wi-Fi hotspots as well. Those are safeguards that the expert committee has recommended. So that's what I have from this TRAI consultation in terms of the context that we're sharing. I hope this was useful and helps in the consultation responses that you're going to look at. I'll hand it over to Apar for his comments.
Thank you so much, Nikhil, for providing me space here. And clearly, our long association working on this issue shows that while we have aged, this issue remains young for policymakers. And I hope people at your home and friends around that place are safe due to that flooding. So if you look at the consultation paper, right, and the way consultation paper is drafted, I would like to draw attention to two broad categories which are there, which may help people here, especially those who are in policy shops or who are at companies, to understand what are the parts they need to actually comment on. So Nikhil has very clearly set out that there are two primary objectives. I'm just re-emphasizing them. So if you look at chapter 2, it's dealing more in terms of regulation, in terms of licensing frameworks for OTT communication services. But also the definition of OTT communication services is open today to definition and is the first question prompted by the TRAI. So just because you're not operating an internet-based messaging platform does not mean you may be naturally excluded for this consultation. So my first recommendation would be to look at the consultation paper and workshop your crisis scenario through it. Because the recommendations may lead to a certain regulatory development at a later point in time. The second part of the consultation paper relates to internet shutdowns. And I think that is the primary jurisdictional justification for the Department of Telecom in pushing this consultation towards the Telecom Regulatory Authority of India. If you see recent consultations which have been done by the Telecom Regulatory Authority of India, it seems to be much more interested around the regulatory aspects of stimulating economic investment, innovation, and other aspects rather than looking at curtailment, restrictions, and much more regulatory aspects around net neutrality or the older issues as such which were there. So this is essentially, if you look at the annexures to this consultation based on a back reference sent in July last year to the TRAI and then pushed subsequently by the DOT again to the TRAI. I think this context is also important if you look at the telecommunications bill, which did a very sly thing, right? It was taking away the power, and I'll just read, the bill was basically proposing to amend clauses in the TRAI Act, which gave the regulator power to notify tariffs at which telecom services are to be offered, but also was removing the provisions for referencing and back referencing recommendations between the DOT and the TRAI. What that essentially meant was that TRAI would stop acting as an advisory body to the DOT, and DOT could take those decisions without consulting TRAI itself. So essentially what I'm trying to say, if you look at the consultation paper a little much more closely, especially in terms of part 2 on licensing, you notice the TRAI has culled out a lot of studies from the ITU, from BEREC, which is the Association of European Regulators. It has culled out also recommendations from ARCEP, which is the French regulator. And a lot of it is actually in favor of statements which are saying that evidence does not exist for regulating OTT services en masse and for revenue functions, which may actually end up supporting the telecom service providers. And if you look at, there's also a table given in terms of the ARPU, which is the average revenue per user, which has actually grown, and then they show a split how it's moved from voice and SMS towards data, and the ARPU has actually risen. So through numbers, through studies, chapter 2, which is part 1 on licensing of OTT services, I think goes back to Nikhil's point, which is on security. And I think rather than the economic element of the TSPs self-embracing this and saying that, wow, OTTs are going to be regulated and we are going to get a revenue share. I don't think so that's likely. My impression is that this is a consultation posed towards security-based aspects, which also then emerge from Chapter 3. Chapter 3 is with respect to internet shutdowns, which is the basis of the back reference and the annexures to this consultation. And if one looks at what is the right now the litigation climate around internet shutdowns, it is posed towards actually carrying from the Anuradha Bhasin judgment, in which again the Supreme Court made an error, in my view, in which it said that the government must examine selective whitelisting of websites or allowing a permissive based access on categories of services, which was actually implemented in Jammu and Kashmir. And I think there's an analysis by Rohini and Prateek Vagre on the MediaNama website, which may be shared as to how it actually played out, because it was unimplementable in terms of technology. Workarounds were easy, and sometimes the intended websites did not actually load by itself for banking functions, for remote education, etc., which were deemed in the categories which were whitelisted. So more or less, my view around this consultation is that it may lead to certain recommendations which may help up bolstering provisions under the telecommunications bill, which has gone into some controversy. Secondly, I think so with respect to internet shutdowns, there's a real danger that there is a recommendation which may emerge, because it seems reasonable for a whitelisting approach of a categorization. And here, if you go back to why the DOT is sending this letter, it is saying there's a recommendation from a parliamentary standing committee report, which was given, and it is asking us to examine whether limited internet shutdowns can be done. This is one of the 7 recommendations of the Parliamentary Standing Committee. And after the Parliamentary Standing Committee makes these recommendations, it also has an action taken report, which is tabled this year in February. Okay, I'll share these links with Nikhil, so he can share it with you. And the DOT says, no, we cannot change the rules and include local representatives like MLAs and councillors in the committees who decide internet shutdowns. No, we will not conduct an economic study as to the impacts of internet shutdowns. No, we will not create a centralized database for the publication of the orders. And this obtains censure consistently by the standing committee in the action taken report. And if you look at the recommendation for limited internet shutdowns, for whitelisting, for certain class of services, if you look at the language that emerges from submissions by the DOT by itself, they say that we can do this. It may be more proportionate. So it is not an idea which emerges organically from the standing committee by itself. So what I would ask people, because there are a lot of people who are here from companies, they are from the private sector, is to also consider the question as to whether your service will be part of that criteria, which will be an essential service, or maybe banned for long periods of time in different regions of India, thereby increasing the burden on you for challenging them, or in terms of representations towards different state governments, rather than a centralized ministry under the union government by itself. So with those comments, Nikhil, I think so there may be some interest towards questions and interactions. I'll take them if they do flow later. Thank you so much for this opportunity. And we all benefit from these kind of member calls that you organize and the archival record at MediaNama.
Thanks, Apar. I think we can stop recording now, so we'll take questions.